right, as I indicated yesterday, the 2 steps remain to be completed before you get to begin your deliberations. The next step is that each side will make what we call a closing argument for the plaintiff and defendant Barber, since they're, again, Mr. Lucas, with his issues not being tried to you, will have to make a closing argument to you. And then I will give you the final instructions of law. I'm going to read them to you initially, but you'll get written copies of them in the jury room. And then you get to begin your deliberations. Now, in regards to closing arguments, let me remind you that what the attorneys say is not evidence, but closing arguments are an opportunity for each side to summarize for you what they believe the evidence has established. The plaintiff gets the opportunity to go first, then the defendant barbers get to make a closing argument through their counsel, and then the plaintiff, because she has the burden of proof, gets the opportunity to make a rebuttal argument. So, Mr. Grauer, for the plaintiff. Thank you.
Thank you, everyone, for your final moments of indulgence. I sincerely appreciate it. I know it's been a long week, and it's coming to a conclusion. So, please briefly indulge me for a couple of minutes. So, you've met my client, a mother, former nurse, practitioner in various arts of healing that I can't pronounce, and a trainer and a foster to dogs. You've also seen my client, admittedly, in moments of great frustration caused by the highly abnormal condition of being videotaped for 4 consecutive years instead of arriving at a solution. And you've seen why we're here now. Her neighbors are indeed refusing to do the right thing. They're hiding behind the city's unwillingness to require them to do it. You've heard it. I don't have to. We don't have to. Based upon the exhibits you've seen and the testimony you've heard, Ms. Crozier, Kathleen, has proven by a greater weight of the evidence, meaning evidence that outweighs the evidence opposed to it, the following. The barbers have acted negligently by interfering with the flow of surface water entering plaintiff's land. And Kathleen has suffered damages due to that fact. Let's take those in order. 1, negligently interfering with the flow of surface water. Despite Mr. Barber having a multi-decade career in roofing, 2 of his downspouts were pointed directly at Kathleen's driveway in violation of the city's ordinances. With that long of a career, I would ask myself, how is it possible that that is an accident? With no violations in his work history. How are these the only ones? I have to ask myself that. And the barber's backyard, which was largely green space when they bought it, and after building the house, still largely green space, is now taken up by an addition, which needed a variance for how far it was set back. A patio behind that addition, for which no variance was applied for, and a concrete driveway that's impervious. Since the fall of 2019, the Barber patio and the contours of their landscape beds behind it have combined forces to flood the south side of Kathleen's garage and driveway. That flooding rapidly accelerated the deterioration of that south wall of her garage. So rapidly, in fact, that it required a temporary repair to keep that side from collapsing. And the flooding also caused several driveway blocks to heat. Now, you heard driveway blocks pitch, the freezing of water changes it. You have to ask yourself, why isn't that uniform across your driveway? Why is it just in the area that the water from the Barber property is coming over? For several days now, I won't bore you, not going to play any exhibits, you've seen all these photos. You've seen all these videos. And I have to think of it this way. If it's not right what they're doing, it's wrong. There's nothing in the middle. If it's not right, it's wrong. And Kathleen has suffered damages. The estimates from A1 Concrete and the Levon Group are in plaintiff's exhibit book that we'll go back with. They're stipulated to. There's no question about it. And you've seen them on the screen. They total $13,686. And she's paid $2,100 to date. That was for the repair on the south side of the garage. Kathleen's not asking for a new garage. She prefers her older garage. the aesthetics of it, and the fact that it stood the test of time, even under these circumstances. Let's switch gears to the swale. When provided with the engineer's design for a swale to channel water along the property line, the Barbers rejected that solution. And that idea you've seen was not original. Kathleen didn't come up with this idea. It was a requirement of the city placed in writing on the as-built plan for the property. And that requirement, as you saw, was the only written directive of the city concerning surface water drainage in that area. You've heard the chief building inspector say things like, and it might not be perfectly direct quotes, but from my memory, a swale is not within my expertise. When asked direct questions about it, that's not within my expertise, or that's not within my job description. And he did not contact the city's engineer, who he otherwise collaborates on issues of grading, despite the engineer dealing with that particular issue. It's a refusal to address the problem that we're dealing with here. And you've heard the Barber's expert criticize Kathleen's expert's design, despite not being able to remember the last time he designed one himself, despite not being able to remember the last time he even opened the CAD program used to design that. So many excuses. The Barbers would have you believe that none of Kathleen's legitimate complaints matter because her garage is old. We all saw that. But that ignores these facts. The garage has stood for almost 90 years. While imperfect, it does not deserve an accelerated death. It's not beyond repair. And moreover, despite visiting Kathleen's property multiple times, and mandating that other repairs to for instance, the sidewalk, be implemented when she purchased the property, the city has never cited the garage for a violation. The Barbers would also have you believe that none of Kathleen's legitimate complaints matter because the city signed that yellow slip at the end 5 years after construction began, saying all the city inspections were completed. But how can I trust that? That indisputably missed the downspouts, which have never changed. The downspouts that drain water in the same area where the swale was supposed to be. So, as promised, you've been presented with a lot of complicated jargon, a lot of distractions. All of them amount to excuses and a refusal to address the problem. The bottom line here is that the Barbers did not do the right thing. They refused to do the right thing because they did not have to. You heard that yourself yesterday. Did not have to. The truth is, they don't have to send their water to Kathleen's property. They simply don't have to do this. They're even halfway there. Mr. Barber believes there's a swale, or something like a swale, taking water in the direction it should go. They don't have to leave it an unfinished problem. The current situation is their intent, it's their choice, and I asked you during voir dire whether you'd have trouble holding your own neighbor accountable in the event that your own neighbor did something or failed to do something which caused damage to your property. Well, here we are. You've seen it all. The Barbers need to be held accountable. It's finally time.
Thank you, Mr. Grauer. Should you sit for the defense?
Inviting. You look at the trees out. You look at these drawings from above. It seems really simple. You just draw a squiggly line. Once you put a swale here, because you know that on this street, this is where the water's going. And it's only after you come out of the sky and stand on the ground and look at what this means here that you realize it's not an unreasonable thing. 45-degree slopes coming right up the edge of the driveway to make this work. It's 5 foot across and a foot down. where the main drain fills with water way off the driveway, roots the entire track, and people park their cars. And we're not talking about the word swale as Dean, Sue, or anybody other than an engineer thinks about the word. When you see the word swale on these concept drawings, whether it's the scribbling of the city engineer at the preliminary stage of the interactive process, or whether it's the conceptual drawing by Ms. Lewin, looking at it from above, let's put a swale here. The engineering meaning of the word swale is what she's provided in that document, and what Mr. Paulo showed you the cross-section of. And as Ms. Lewin explained, from an engineer's perspective, the word swale includes at minimum, according to the Ohio Environmental Protection Agency, EPA, the Ohio EPA, a 1% slope. That's what swale means in engineering. When you take a 1% slope, this is the minimum. You can go more than that if you're going to build a swale in a shopping center parking lot, whatever. But at minimum, it has to be 1% to have an appreciable difference in the water flow. So when you do that here alongside here, you end up with these depths as you go along. And that's why it's reasonable to infer that when you stand there on the ground and you're talking to Mr. Barber about how he's going to spread his topsoil, and you realize you can't be having this ditch right off the driveway, other solutions are found. Even Ms. Lewin, after presenting that flat drawing, not a final design concept, sketch, an idea, of a swale from above, realize, wait a minute, all that water is going into the drain is tied to the foundation eventually. Can't have that. And let's try some other things. But the other thing she's talking about will address the water undercutting the foundation of the neighbor's home, but it doesn't address the slopes. Because her other ideas are, well, we'll just dig even deeper and we'll put a dry sump under this thing, which would be basically an underground cavern filled with rocks. That all this water will sit in that swale and percolate down into through the topsoil, and then go out sideways into the Barber's basement foundation, or under exposed driveway. Still under. So the idea of a swale is an attractive one from above. But when you stand on the street and see what you're working with here, it can't be done. It's unreasonable and it's flat out dangerous. It helps us understand why, the way Gene explained, when the city's engineer and officials would come out and look at his property during the course of construction, they talked about solutions. They talked about how he graded the topsoil in a way that they liked. They had to put a drain near his front porch to take some of the downspout water, and some of the water that's in the side yard went through his way to the street. You can't capture it all. And the flow patterns that are developed as a result of it all are what the city views as being possible with what they were working with. Now, the house that the Barbers lived in was there when Kathleen bought her house. It had been there since 1986. It had been there. The landscaping beds were all there when she bought her house. The addition was already there when she bought her house. A patio, granted, a brick paper patio. It wasn't stamped concrete like we have now. It was a brick patio that was put in back in the day. It was there when she bought her house. And this was all above grade, and this was all flowing in this direction. And do we have that pointer, that green pointer? I don't need the screen, just green pointer would suffice. So, you know, if we haven't committed these to memory by now, I'll be surprised. But when Ms. Lewin sat in that chair with this pointer and Mr. Grauer asked her to show us, if water lands here, if water lands there, where does it go? And it would be, well, if it lands on the patio, it'll flow back and into the yard, and then over here, and then slowly make its way to the street. And if it lands on the grass, it'll go back here, but it'll curve forward to that corner, kind of by the front of the garage, and then it'll slowly make its way to the street. If it lands on the flower beds, it'll flow forward towards the street, but then it'll go this way and curve out, and make its way eventually down the side yard to the street. And she talked about how when it's fully saturated, you'll get puddling, but every single line that she drew did this. eventually made its way to the street, which is consistent with Mr. Barber's discussion about the interactive process with the city, because they hadn't graded topsoil in a way that encouraged the water to go like this. Now, is there a 45-degree slope engineered swale, the way the engineers conceive of it when we come up with the concepts to begin the discussion? No, because when you get there, as I said, it's unworkable. But what there is that movement, and there's pictures and there are videos where you say, here comes the water, and there it goes, and then you look down the driveway and there's water all along their side yard, migrating its way to the street. You go to get close, you can't capture it all. That is the result of the interactive process. That's not hiding from anything. That's working with the city. And that's getting final approval on what's there. And this whole situation was revisited time and time again as they went through the process of working on the home with the city. The question ultimately, in this case, you're going to hear instructions of different legal theories, and I want you to focus. It's going to boil down to one cornerstone concept. Is the barber's use of their land reasonable or unreasonable under all the facts and circumstances? So all the language you're hearing, that's the decision. It's all going to boil down to that decision. Because we're talking about whether the flow of water is reasonable, unreasonable, whether there's trespass claims and nuisance claims based upon these things. But all those instructions are going to lead to that one cornerstone decision. Is the use of this land reasonable or unreasonable? And that's why I asked Mr. Keller and the other witnesses, is a concrete sand patio like this consistent with the character of this residential neighborhood? And it is. I mean, I've seen it, we've all seen, that's just how they're building patios today. And Mr. Caldwell, the engineer, explained how this concrete patio necessarily by code tips away from the house, but there's a trench around it, filled with gravel, with river rock, that you see in the pictures. You'll see in the pictures if you haven't noticed it yet. This isn't concrete dumping off on the grass and then off it goes. So when Sue is scared by claims that are being made, she wants to see how does my patio drain, and she takes a video of one of those and says, okay, well, it goes back. Fine. Well, it doesn't flow off there right into the grass. Mr. Caldwell is saying that it flows off the edge of the patio all the way around into a gravel-filled trench to catch it. And then that gravel is covered by river rocks that are placed there that are decorative. And there, the water migrates in a dispersed way into the sewers. So that's a reasonable way to address building a patio. At the end of the day, all of the water in a fully saturated situation is not going to be caught by mulch, it's not going to be caught by grass, it's not going to be caught by anything. It's going to flow. And here, the topsoils are shaped to flow out that way. Now, if it wasn't for the landscape beds that tip forward towards the street, all the water in this yard goes straight into that garage. If this was just a flat grass square and it got fully saturated, all the water goes straight into the garage. It's downhill. But instead, it's kind of encouraged out towards the street. The perfect solution? No. It's what they got. What you'll see in these exhibits, and as I mentioned in opening, there's only so much time in the day or a week, I guess, but there are pictures in here on M, exhibit M, and these have all been agreed and stipulated. You can have them compared with M again and again. I'm not just going up there, I'll just say these are pictures. So as Sue talked about, when the neighbors start sending videos and pictures to the city complaining about things, and she's out there trying, okay, well, I should take pictures and videos to defend myself. And I can't be home all day, so I put the camera pointing at this, and now I'm seeing things that I didn't expect to see either. But she took some pictures of what's going on. These pictures are dated, and when she'd see her neighbor taking pictures of the photo by her, she took a couple of what the side of her garage looks like. This is on the other side of the private property. It's just the nature of this neighborhood. Okay? And it's fully saturated and it's flowing from the neighbors to the neighbors. It's not a problem. And a few years later, it's gone. There's another picture that you see of the barber's garage from the inside. There's one that shows that there's nothing wrong inside the garage. And why? Because it's up off the ground like it's supposed to be. That's just the way we got it. That's why the cause of damage to the garage is not the presence of water. Water happens. It's sitting in the ground over there. every money with the garage that we would prepare when she bought the house. There will be two verdict forms. You can fill out. One says, and there's a box you can check. You can check the box for the defendants, and we all go home. You can check the box for plaintiff, and we put in a dollar amount. That's money. That's what this is for. Today, we're all here to spend the week here for money. And at the end of the day, the money is for conditions for the garage and the pad that have existed for decades. They all agree it's existed for decades. The garage repairman agrees. These conditions existed for decades. Our engineer agrees. These conditions existed for decades. Now, Hoggle, the rest agrees. These conditions existed for decades. We know that because the prior owner hid these conditions with bricks. We put bricks in those areas where the sill plate had rotted all along, even sliding some underneath the rotted studs. And so I would suggest if this project has a claim against anybody, it's the prior owner. As you walk into this garage as a lay person, you look around, it looks fine. You see bricks, but I don't know what that means. I don't know to go down with a flash up in the wall and poke wood and see what's under there. But that's what was there. And we know that because the bricks were there. And the bricks can't be in the same place where the wood sill plate is, if the wood sill plate is there. So the wood sill plate is gone and the bricks are in place of it. So we know that these conditions existed then. And we also know from the garage repairman and from this that the repair that's required 20 years ago, and this condition exists because at that moment, the load-bearing walls aren't working anymore. This is an unstable, unsafe place. The repair is the exact same repair that they're talking about asking for money for today. It's to lift the garage back out of the ground, put cistern studs on, put sill plates in, add the foundation it was supposed to have, and slope away from it. That's the repair that this garage needed when she bought the house. The repair is no different. Now, is the amount of rock in the already rotted out sill plates more today than it was when she bought the house? Of course it is. It continues to rot. It's an ongoing process, and nothing's been done about it. There's an instruction about mitigation of damages. Ms. Crozier knows that she's had water coming in her garage prior to the change of patio. She's testified to that. She says the amounts are different, but she's seen water infiltrating her garage the whole time, and nothing was done. The landscaping outside her property isn't sloped away. The sill plate's not brought up. That's what reasonable people do. That doesn't involve unreasonable burdens, humiliation. That's part of the instruction on mitigation of damages. You're expected to do things to avoid further loss. You don't have to do crazy things that involve humiliating yourself or unreasonable burdens, but reasonable things. And the prior owners left that thing in a condition that was already needing all the repairs to talk about. But regardless, nothing was done when she saw water coming in for all those years. So that's a mitigation of damages issue. And the other burden, that the only burden aside from she did nothing that she's testified to, is the passage of time. I have an affirmative defense here that says this: even if you find that the way that backyard.
Can we approach?
Yes, please.
Okay.
Objections overruled. You may continue, Mr. Doucette.
So, so there's a statute of limitations on it, which means that if you think you have to renew, you need to bring it to the court within 4 years. I'm sorry. I don't want to be yelling at you people, so that's why is this okay?
That's good. Yeah, your voice is going low.
Is it, okay, thank you. All right, well, Ohio has a statute of limitations, and then it's my burden. If I can show it, it works. If I can't show it, it doesn't. And what it says is this: even if you were to think that the patio and the landscaping and the way the city had them shape the topsoil and all of that is unreasonable for some reason, even if you thought for some reason that that was why the garage looks the way it does and would need the repairs that she needs for some reason, despite all the testimony and all the evidence that came from this stand, if that's what you find, there's still an affirmative defense. I can say, wait a minute, it's more than 4 years old. So this lawsuit was brought in, the date you'll hear in the instructions, I think it's the later part of 2022. So that means if 4 years before that, these conditions existed, one day before that, these conditions existed, these repairs were already required, then it's time barred. You can't include that with damages that would be involved in this case. That's just the way it is. Because of passage of time, I always place that in there. So I just bring that up because you can be instructed on it, and that's what that date is for. You can't include that in any damages for it. Because this is about getting money, but you can't get money for something that already existed more than 4 years ago. Okay, before this lawsuit was brought. So that's what that means. And there's no question that these conditions existed more than 4 years before this lawsuit was brought. They've been there for decades. And even the way the original driveway pad and the original floor of the garage all work together tells us that as well. There's newer driveway headed to the street that flows and tips into the street, but the old driveway pad in front of the garage matches the slope of the garage floor. It all works together. That's why Matt Caldwell says everything he sees tells him this was all poured together at the same time. So again, that's the issue of time part. But I don't think, honestly, you're going to get there. I don't think you make it to that point here. I think the first question is whether or not the bargain use of the property is reasonable, and under all the facts and circumstances that we've heard about, the way the city works, gave final approval, have to reshape the topsoil and the yard drain and all that stuff. I think that's the end of the case right there. We all go home. If it was reasonably signed the verdict for the defendants, and we're done. And this is finally over. If we look at disclosure garage, there's a couple things that I just wanted to point out. One is that the way that we all agree that there's water that's tipping from all directions to the garage. The amount of water coming is different because one part of the garage is uphill and downhill. But even after capping the gutter in the back, we're still having water infiltrating to the neighbor's yard back there because we've got pictures that she put up. She said, look, even after I capped the gutter, if you look in the back corner of the garage over there,
You're turning your back on the jurors. I think that's a part of the problem too. We keep turning around and talking that
way.
way.
They tell me not to do it. Like I learned that a long time ago and I never remember it. But so there's still water coming from other sources there. The water from the barbers is kind of flowing out towards the front. And Ms. Lewin told us it's not backing up there because it flows out. So I'm just going to look at my notes real quick and then get out of the way. So that's it for me. John's going to go, Mr. Brower's going to have a chance to get up and talk to you again. I'm not going to get the chance to come back. I'm just going to rely on you to remember all the stuff you've heard about me. Thank you very much.
Thank you, Mr. Doucette. Mr. Grauer for the plaintiff.
Sure. Promise this is 1 minute. So, addressing a couple of quick points here. Couple of very, very quick points. The condition of the garage does not change what the water is doing. It's very important. When you're talking about a trespass, when when you're talking about a nuisance. You could look at the garage, take it as it is, and that condition doesn't change what the water is doing when it comes across the property. Second, in relation to the statute of limitations that was referenced, the complaint having been filed in 2022, you heard over and over and over, and saw picture after picture after picture, that the patio correlates to the tremendous increase in water and when that occurred, late 2019. We've heard it repeatedly. So when you're talking about 4 years, you understand the correlation between the patio, when it started to increase so significantly, and the timing between those two. Lastly, one of the more significant things I heard yesterday is Suzanne Barber would prefer things to be different. Would prefer the patio to drain differently than it is. Would prefer that there's a more reasonable alternative than ours relative to the swale, right? But you've heard this has been going on for so long. If that's the preference today, and she was on notice in 2022 or earlier, why nothing? Why nothing until now? That's what brought us here today, and that's all I have to do. Thank you.
Thank you. Ladies and gentlemen, if you want to stand and stretch for a brief second, we're going to get right into the jury instructions. All right, well, the last step that needs to be completed before you get to begin your deliberations is that I need to read to you the final instructions of law. Now, as I've indicated a couple of times, you are not expected to memorize what I'm telling you. You're going to get written versions, written copies of these instructions. You'll have multiple copies of them in the jury room with you. But I am required to read them to you, so I'm going to do it this time. I am going to put it up on the big screen, so if you want to follow along with me, you can. You don't have to. You can just sit back and listen as well. But with that said, let's get started. Make that a little bigger. Let's see. Probably better. All right. Members of the jury, you've heard the evidence and the arguments of counsel. It is now the duty of the court to instruct you on the law which applies to this case. The court and jury have separate functions. You decide the disputed facts, and I give the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or to apply your own idea of what you think the law should be. Now, the person who claims that certain facts exist must prove them by a preponderance of the evidence. This duty is known as the burden of proof. The burden of proof is on the plaintiff to prove the facts necessary for her case by a preponderance of the evidence. Preponderance of the evidence is the greater weight of the evidence. That is evidence that you believe because it outweighs or overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with the quantity or the greater number of witnesses. In determining whether an issue has been proved by preponderance of the evidence, you should consider all the evidence, regardless of who produced it. If the weight of the evidence is equally balanced, the party who has the burden of proof, in this case the plaintiff, has not established such issue by preponderance of the evidence. Now, the evidence in this case includes all the testimony received from the witnesses, the exhibits that are admitted during the trial, any facts which the court requires you to accept as true, and any facts or stipulations that are agreed to by counsel. Evidence may be direct or circumstantial, or it could be both. You must decide from all the direct and circumstantial evidence taken together whether the party who has the burden of proof, in this case the plaintiff, has met that burden. Direct evidence is the testimony given by a witness who has seen or heard the facts to which that witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. As an example, if you awake in the morning and see the ground is covered in snow, that is circumstantial evidence that it snowed earlier. Likewise, if you see human footprints in sand, that is circumstantial evidence that someone had previously walked there. To infer or to make an inference is to reach a reasonable conclusion or deduction of fact, which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. You may infer a fact or facts or reach a reasonable conclusion about a fact or facts only from other facts and or circumstances that have been proved by the greater weight of the evidence. You may not, however, infer or reach a conclusion about a fact or facts from a speculative or remote basis that has not been established by the greater weight of the evidence. Further, you may not build one inference on another inference, but you may make more than one inference from the same facts or circumstances. Exhibits and testimony related to them have been introduced. You will determine what weight, if any, the exhibit should receive in light of all the evidence. If there is a copy of an exhibit, you should consider it the same as an original. If there are deletions or redactions, you must not consider those parts. The exhibits are identified by their numbers or letters. The fact that numbers or letters may be missing or omitted shall not be considered for any reason. You will have with you in the jury room as exhibits certain video recordings which are introduced into evidence. If and whenever you wish to view any of these recordings, there is equipment in the jury room which the bailiff will assist you in setting up and instruct you on how to use so that you may consider this evidence. The evidence does not include the pleadings, any questions by counsel that contain assertions of fact, or any statements of counsel made during the trial, unless such statements were an admission or agreement admitting certain facts. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers ordered stricken or to which the court sustained an objection or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not guess why the court sustained the objection to any question or what the answer to such question might have been. You must not consider as evidence any suggestion included in a question that was not answered. You are the judges of the facts, the believability of the witnesses, and the weight of the evidence. To weigh the evidence or determine the greater weight of the evidence, you must consider the believability of the witnesses. You will use the test of truthfulness, which you will use in your daily lives. These tests include the appearance of each witness upon the stand, the manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things concerning which the witness testified, accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding this testimony. Using these tests, you will assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because that witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to determine what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Now, normally a witness may not express an opinion. However, one who follows a profession or a special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions have been asked of the expert witnesses after they had disclosed the underlying facts or data. It is for you, the jury, to decide if such facts or data which the experts based their opinions are true, and you will decide what weight to give such evidence. Questions may have also been asked in which the expert witnesses were permitted to assume that certain facts were true and to give an opinion based on that assumption. You must decide whether the assumed facts in which the experts based their opinions are true. If any assumed fact was not established by the greater weight of the evidence, you will decide the effect of that failure on the value of the opinions of the experts. As with other witnesses, the duty of deciding what weight to give to the testimony of experts rests entirely on you. In deciding this weight, you shall consider the skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing credibility and deciding the weight to give to the testimony. You are not obligated to believe any of the experts merely because he or she is one. Now, as for the issues in this case, Plaintiff Kathleen Crozier brought suit against defendants Eugene and Sue Barber for continuing trespass and private nuisance. Specifically, plaintiff claims that the water runoff from the rear of the defendant's Barber's property has resulted in a continuing trespass and private nuisance due to the unreasonable diversion of water onto the plaintiff's property. Plaintiff also brought suit against the city of Willoughby for equitable relief, which the court, rather than you, the jury, shall decide. Now, as to the trespass claim, the plaintiff contends that the Barber defendants trespassed in the plaintiff's land, causing damage to the plaintiff. To establish this case, the plaintiff must prove by the greater weight of the evidence that the plaintiff had a right to possession of the land and that the Barber defendants breached a duty of care by unreasonably interfering with the flow of surface water entering the plaintiff's land without the permission of the plaintiff, causing damages. Now, below I will explain the duty of care under the principles of negligence as well as causation and damages. To establish a right of possession, plaintiff must prove by the greater weight of the evidence that the plaintiff holds record title to the land. Now, in regards to nuisance, plaintiff also claims the Barber defendants created a nuisance and that the nuisance caused damages to the plaintiff. Before you can find for the plaintiff on this claim, you must find by the greater weight of the evidence that the Barber defendants breached the duty of care by unreasonably interfering with the flow of surface water entering the plaintiff's land, which caused annoyance, injury, or inconvenience to the plaintiff or endangered the comfort, health, or safety of the plaintiff. Again, below I will explain the duty of care and the principles of negligence as well as causation and damages. In deciding whether a nuisance exists, you may consider, among other factors, the nature of the injury, the frequency of the disturbance, the character of the neighborhood, and the past actions taken by the Barber defendants to reduce the disturbance. You must consider the comfort and convenience of persons of ordinary tastes and sensibilities. You must be guided by the generally accepted standard of comfort and convenience. Trifling and insignificant annoyances or inconveniences do not constitute nuisance. Likewise, unsubstantiated or unrealized fears do not constitute nuisance. Nuisance is a question of degree, depending upon varying circumstances. Now, regardless of whether the plaintiff's cause of action sounds a nuisance or trespass, a defendant's liability for interference with surface water flow is controlled by principles of common law negligence. Under principles of common law negligence, the plaintiff must show that the defendant owed a duty of care, that the defendant breached that duty of care, and that the defendant's breach of duty was the direct and proximate cause of the plaintiff's damages. Negligence is a failure to use reasonable care. Every person is required to use reasonable care to avoid injuring another's property. Reasonable care is a care that a reasonably careful person would use under the same or similar circumstances. The duty of reasonable ordinary care regarding flow of surface water is known as the duty of reasonable use. Under the law of Ohio, the defendant has a right to make a reasonable use of the defendant's land even though the flow of surface water is altered by their action and even though it has caused some harm to others. A defendant may be found liable for their actions only when those actions are unreasonable in light of all the circumstances of the case. In surface water disputes, the plaintiff bears the burden of proving that the defendant's acts were unreasonable. Unreasonableness is determined from an objective point of view. The question is not whether the plaintiff or the defendant would regard the use as unreasonable, but whether reasonable persons generally, looking at the whole situation impartially and objectively, would consider it unreasonable. The question of the reasonableness of the use in a given case must be determined as a question of fact under all the attendant circumstances. In deciding whether reasonable care was used, you must consider whether the Barber defendant should have foreseen under the circumstances that the likely result of an act or failure to act would cause damages. The test for foreseeability is not whether a person should have foreseen the damages exactly as it happened to the specific property. The test is whether under the circumstances a reasonably careful person would have anticipated that an act or failure to act would likely result in damages. A party who seeks to recover for damages must prove not only that the other party was negligent, but also that such negligence was a proximate cause of damages. Proximate cause is an act or failure to act that in the natural and continuous sequence directly produced the damages and without which the damages would not have occurred. A person is not responsible for damage to another if his or her negligence is a remote cause and not a proximate cause. A cause is remote when the result could not have been reasonably foreseen or anticipated as being the likely cause of any damage. The test for foreseeability, again, is not whether a person should have foreseen the damages exactly as it happened to the specific property. The test is whether under the circumstances a reasonably careful person would have anticipated that an act or failure to act would likely result in damages. If you find that the Barber defendants were negligent by unreasonably interfering with the flow of surface water entering the plaintiff's land, and the Barber defendants' unreasonable interference with the flow of surface water entering the plaintiff's land proximately caused damage to the plaintiff, then your verdict must be for the plaintiff. However, if you find that the plaintiff failed to prove that the Barber defendants unreasonably interfered with the flow of surface water entering the plaintiff's land, or if you find that the plaintiff failed to prove that the barber defendant's unreasonable interference with the flow of surface water entering the plaintiff's land proximately caused damage to the plaintiff, then your verdict must be for the barber defendants. Now, as for damages, if you find for the plaintiff, you must then determine from a preponderance of the evidence the amount of money, if any, that should be awarded to the plaintiff. If the damage to the property is temporary, such that the property can be restored to its original condition, then the owner may recover the reasonable cost of these necessary repairs. You may also consider whether the plaintiff suffered personal annoyance and discomfort. If you decide the plaintiff has suffered personal annoyance and discomfort, you must then decide what amount of money the plaintiff should recover, if any, in view of the annoyance and discomfort to which the plaintiff may have been subjected. When considering annoyance and discomfort damages, no precise rule for ascertaining the damage can be given, as the degree of personal annoyance and discomfort is not susceptible to exact measurement. Although the plaintiff need not have suffered bodily injury before you can award damages for annoyance and discomfort, you must find the plaintiff has suffered actual physical discomfort as a result of the nuisance. Any amounts that you have decided to award to the plaintiff or any element of damages should not be considered again or added to any other element of damages. You shall be cautious in your consideration of the damages, not to overlap or duplicate the amounts of your award, which would result in double damages. Likewise, any amount of damages awarded to the plaintiff for annoyance and discomfort must not be considered again as an element of damages for loss of use or any other element of damages. If you find for the plaintiff you cannot consider any amount for a pre-existing condition, however, you'll consider and decide an amount for whatever aggravation or acceleration expenses you find were proximately caused by this defendant. It is the extent of the aggravation or acceleration for which the defendant is responsible. Aggravation means that a physical condition already existing was made worse by this defendant. Acceleration means causing a condition to reach a point that it would have normally reached, but at a measurably earlier time. Where a defendant is not responsible for the pre-existing condition, but only for the acceleration of that condition, the defendant is only liable for the damages proximately caused by the acceleration. If you find for the plaintiff, but also find that the plaintiff failed to prove by the greater weight of the evidence any amount of damages, you may award the plaintiff nominal damages. Nominal means trifling or small. The defendant claims that plaintiff failed to mitigate her damages. If the defendant proves by the greater weight of the evidence that the plaintiff did not use reasonable diligence or make reasonable efforts under the facts and circumstances and evidence to avoid loss or lessen damages caused by the defendant's negligence, you should not allow damages that could have been avoided by the exercise of reasonable diligence or reasonable efforts to avoid loss. The plaintiff, however, is not required to take measures that would involve undue risk, burden, or humiliation. If you find for the plaintiff, the defendant claims that some or all of the plaintiff's damages occurred more than 4 years prior to the plaintiff's filing of the complaint on December 12th of 2022. If the defendant proves by the greater weight of the evidence that some or all of the plaintiff's damages occurred more than 4 years prior to the plaintiff's filing the complaint, you should not include those damages. The court has now given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and how to prepare your verdict. When you go to the jury room, your first function will be to select one of you to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. That person serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict form is returned to the court after you have reached a verdict. Now, your initial conduct upon commencing deliberations is a matter of importance. It is not wise to express immediately a determination to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused and you may hesitate to give up your opinion, even if shown that it is not correct. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after discussion of the case with the other jurors. Do not hesitate to change an opinion if you are convinced that it is wrong or if the discussion persuades you that you should. However, you should not surrender your considered opinion concerning the weight of the evidence to be congenial or to reach a verdict solely because of the opinion of other jurors. If you have a question during your deliberations, it should be discussed in the privacy of your jury room. It should not reflect the status of your deliberations. It should be reduced to writing, noting the date and time of the question, so there will be no misunderstanding as to what you request, and it should be signed by the foreperson. It should then be delivered to the bailiff who will submit it to the court. Please be patient in waiting for a response because the judge must consult with the lawyers for the parties before sending his response. The court will then attempt to answer the question as best as possible. Please keep in mind, though, the court may not be able to answer all questions. Now, in order to conclude this case, it is necessary that at least 6 members of the jury agree upon the verdict. The members of the jury agreeing upon the verdict must sign their names in ink to the form of verdict to which they have agreed. The foreperson need not be among the 6 jurors who have agreed in order to reach a verdict. If 6 jurors cannot agree, you are instructed to report this to the court. Now I ask for the verdict form. We're going to review that at this point. You're going to have this document back in the jury room with you. This is the verdict form where you record the decision that you reach, and you see right there in the middle, general verdict form, and it reads, "We, the jury, being duly impaled and sworn, find the issues in this case as to the plaintiff's claims against Eugene and Sue Barber as follows." And if you're instructed to find for the plaintiff, you'll put an X or a check mark in that line there on the first, where it says, for the plaintiff, Kathleen Crozier, in the amount of, and then you see a $ followed by a blank line. So if you find for the plaintiff, you'll again check off that first line, and then the subsequent line after the $, you'll enter the total amount of the money that you, if any, award to the plaintiff. If you're instructed and directed by the instructions to render a verdict for the defendants, then you, instead of marking the first line, you'll put a X or a check mark in the second line here, where it reads, for the defendants, Eugene and Sue Barber. And then below that, it just concludes by saying, and we do so render our verdict upon the concurrence of blank members of our said jury, and you're going to put in there either the numbers 6, 7, or 8. As I said, you need at least 6, but however many of you agree with that, you'll put that number there. That's 3/4 or more of the total number of jurors. And then each of us said jurors concurring in said verdict signs his or her name here too, this blank day of blank 2024. So you'll put whatever date it is that you reached that decision. And then you see below there's 8 lines. Those are the signature lines for each juror to place his or her respective signature. Juror number 1, Ms. Hanzak, is the number 1. We go along to Ms. Manning, your juror number 4. I think that should coincide probably with the notebook number that you have. Ms. Kint, your juror number 5, and we go along the front row to Ms. Hudek as juror number 8. So again, make sure you know what number you are, but again, I think it coincides with the notebook that you have, and that'll be the line that you will place your signature on if you agree or concur with this decision. Now let's go back and conclude the instructions. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the instructions. During deliberations, the court will place in your possession the verdict form as well as the exhibits admitted into evidence during the trial. You will also be provided with multiple copies of these instructions. Further, you will be permitted to bring into the jury room and refer to, if you desire, any notes you took during the trial. You will not be given anything else. Also, during deliberations, the court reporter will not be permitted to read back any portion of the testimony which you heard during the trial. Now, circumstances in the case may arouse sympathy for one party or the other. Sympathy is a common human emotion, and the law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not permit it to influence your verdict. Thus, you must not be influenced by any consideration of sympathy or prejudice. It is your duty to weigh the evidence, to decide the disputed questions of fact, to apply the instructions of law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a fair and just verdict. You now have been instructed by the court in all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts by preponderance of the evidence. If you have the impression the court has indicated how any disputed fact should be decided, you must put aside such an impression. Nothing said in these instructions or in the earlier instructions, and nothing in the verdict form is meant to suggest or convey in any way or manner any intimation to what verdict I think you should find. That decision must be made by you based solely upon the facts presented to you in this courtroom. Lastly, you are warned not to discuss your verdict until it has been returned to the court, nor are you to discuss the status of your deliberations with anyone. This order must be strictly obeyed. After your verdict is returned and announced in open court, you may discuss the case with anyone, though you are not required to do so. It is a matter of your own free choice. When you have reached the verdict and signed the verdict, you will summon the bailiff, who will then return you to the courtroom, at which time your verdict will then be announced. All right, now jurors who are selected as alternates are not permitted to participate in the jury's deliberations unless one or more of our regular jurors is unable to complete their service due to illness or some other misfortune. We're pleased that nothing like that happened in this case. Fortunately, it does not appear necessary that our alternate will render any further service in this case. So, Mr. Burkholder, you are selected as our alternate, and it will not be necessary for you to serve any further. When the jury convenes in the jury room to commence their deliberations here in just a moment, you'll go in with them, gather your belongings. I don't think you have your badge on, but if you do, oh, all right. Well, make sure you leave it here, or stand up and chase them after. Leave your badge here, and then you will be discharged from any further service in this case. Now, even though you're not required to serve any further, I do need to restrict you still from discussing this case with anyone or revealing to anyone how you would have voted had you been one of our original members here. Once the jury has returned its verdict and it's announced here in open court, you'll be released from that restriction, and you can talk about the case, anything you want about it with whomever you please. Though again, you're not required to. That's a decision for you to make. But at this time, I do want to thank you very much for the service you provided to us tonight. All right. So with that said, Mr. Grauer, anything else you wish to discuss at this point?
No, Your Honor. We thank the court.
Mr. Doucette for
Thank
the
you,
defense.
Judge.
All right. Mr. Lucas, anything you care to?
I just want to thank the jury for their attention, dry subject matter, and I appreciate very much the attention you paid to everybody. Thank you very much.
Thank you. All right, ladies and gentlemen, I want to thank you and express the appreciation of this court as well as the folks here in Lake County for the service that you have provided and that you're going to continue to provide. By providing this service, I again believe you have contributed toward what I believe is justice and justice in the world. At this point, you're going to retire to the jury room and commence your deliberations. The first thing you should do is select a foreperson, and then you commence your deliberations. When you have reached the verdict, you'll sign the verdict in ink as I've explained to you, and use the buzzer to tell us what's going on. Stan will advise you how to go about doing that. We have sort of a Morse code to let us know exactly what it is you're wanting when you use the buzzer. Once you have reached the verdict, you'll be returned to court where the verdict will be announced. Now, at this point, you're on your own. In terms of scheduling or timing, we're not going to tell you it's time to take a break, it's time for lunch. It's up for you to decide. If you guys want to take a break, you take a break. If you want to go to lunch, you go to lunch. If you don't want to, you don't. You don't do it. The only thing I'm going to ask is that if you do take a break or go to lunch, that you buzz Stan first, let him come back here and tell him what you're going to do. We don't want to find you just wandering the halls and not knowing. That's happened once before, and all of a sudden, see everybody's gone. We never know they're So if you take a break or do something, buzz Stan, come back, tell him we're taking a 15-minute break, going to lunch, whatever the case may be, and that's fine. But you're going to decide that from going forward. The last thing I'm going to say is that in regards to deliberations, all 8 of you must be present when you're deliberating. So if you do take a break and say you stay back, or if you go to lunch and you go to lunch together, you can't talk about the case with each other. You can only talk about it when all 8 of you are present and you're locked up in the jury. So at this point, ladies and gentlemen, you may commence your deliberations.
All right.
gentlemen, you have indicated that you have reached the verdict. Is that correct?
Yes.
If the foreperson could please hand the verdict form to our bailiff. In the matter captioned Kathleen Crozier versus Eugene and Sue Barber, general verdict. We, the jury, being duly impaneled and sworn, find the issues in this case as to the plaintiff's claims against Eugene and Sue Barber as follows. For the plaintiff, Kathleen Crozier, in the amount of $1,500. And we do so render our verdict upon the concurrence. Now, all 8 of you signed this, but you wrote the number 6 on the form. Is that? Oh.
Even if we didn't agree.
It says each of us said jurors concurring in said verdict signs their name here too. So there was 2 of you that did not, or was, I'm sorry?
Yes.
Only 2?
Yes.
Okay. That's fine. I mean, as long as 6 of you did that, we're going to have you cross off whoever didn't do it. We'll cross off and initial their signature. That's not a concern. So, ladies and gentlemen, I have to advise you at this time. I said good news and bad news. Good news is you're done with this phase of the trial. The bad news is that there is a second phase of this trial. Nowhere, it won't take that long. But having found that the plaintiff is entitled to compensatory damages against the defendants, you may also now consider whether you will separately award punitive damages. Punitive damages may be awarded against the defendants as a punishment and to discourage others from committing similar wrongful acts. You are not required to award punitive damages to the plaintiff, and you may not do so unless you find that the plaintiff has met her burden to prove by clear and convincing evidence that the defendant's actions demonstrated actual malice. Actual malice necessary for an award of punitive damages is defined as a conscious disregard for the rights and safety of another person that has a great probability of causing substantial harm. Substantial means major or significant and not trifling or small. Clear and convincing means that the evidence must produce in your mind a firm belief or conviction about the facts to be proved. It must be more than evidence that simply outweighs or overbalances the evidence opposed to it. Punitive damages are not automatically awarded in cases where a defendant is found liable. If you award punitive damages, the amount should be fair and reasonable under all the facts and circumstances. It should not be excessive nor influenced by passion, sympathy, or prejudice. If you award punitive damages, it should be presumed that the plaintiff has been made whole for her injuries by the award of compensatory damages. In determining the amount of punitive damages, you may consider all of the following. The harm caused. 1, the harm caused was physical as opposed to economic. 2, the tortious conduct evinced an indifference or reckless disregard of the health or safety of others. 3, the target of the conduct had financial vulnerability. 4, the conduct involved repeated actions or was an isolated incident. And 5, the harm was a result of intentional malice, trickery, or deceit, or mere accident. If you decide that defendants are liable for punitive damages, you must also decide whether the defendants are liable for the reasonable attorney fees of counsel employed by the plaintiff in the prosecution of this action. If you decide that defendants are liable for attorney fees, the court will determine the amount. So, ladies and gentlemen, the second phase is similar to a trial. You decide to make an opening statement. You can call witnesses and closing arguments. So we're going to proceed with that. I obviously didn't know about that going into this. If we'd like to take a brief break, want to get lunch, before we start that, we can do that. My thoughts were if we wanted to start at 1:30, we could start at 1:30, or someone had a hand up. I don't want to talk about anything substantive.
Can we get notebooks?
Yeah, we'll give you your notebooks back. Well, why don't we do this? Go in the jury room, correct the verdict form, So the two jurors that did not agree to this, draw a line through your name and initial it. Talk amongst yourself what you want to do. Buzz stand, and it should only take a few minutes, I imagine, to do that. And then we'll proceed accordingly. I guess I would suggest maybe taking a half hour so people want to grab a bite to eat or something like that if they didn't get anything. Why don't you follow the jury room and speak to your show.
All rise.
And counsel, if you just hold tight and wait and see what we're going to do here.
They're taking a 30-minute reprieve or what?
Okay.
Oh, no, that is
Yeah,
fast.
I want to say, and the jury actually made the decision. I mean, yeah, the jury actually made that decision. That's
Okay,
what I'm understanding. I want to be,
here and not there.
yeah.
Well, I packed.
I want to be certain that I heard them correctly.
You said 1:30?
1:30, yeah, we got group 4, 1:30, you said.
Oh, okay, so no lunch, all right. realize that you've heard the facts. I realize that you've seen the photos, the videos, the exhibits. And my sincere intention is to have as few questions as possible. I mean, you're going to hear the judge instruct on the law that's to be applied to the facts. But let me just briefly tell you, the barbers consciously disregarded the rights and the safety. Kathleen is asking for $1 of punitive damages. $1. That is the punitive aspect she's asking for. An entitlement to reasonable attorney fees. The judge will inform on how those relate. The judge will inform on whether he or you make a decision in regards to those. And that's all I have for you.
$1 will do it. This is revealed why we're here. This is gamesmanship, and it's about getting attorney's fees. But before you get there, you've got to go through this punitive damages phase first. And he's going to get a chance to put my clients back up there again. He's going to take another shot at it. He's going to do what lawyers do best. He's going to try to rattle them. We're already nervous. He's going to put them up there and use words and get them twisted up in a knot. And his goal is that they're going to say something that he can then retwist in his closing argument to try to get punitive damages that, in a real case, are designed to discourage others from committing wrongful acts. In this case, it's $1. I'm grateful for your patience through all of this, and now I just hope that you've got the stamina to sit through this and do the right thing by the party. Thank you very much.
Thank you. Mr. Grau, I'm going to call your first witness.
Thank you. We call Mr. Eugene Barber.
Ladies and gentlemen, as you see, we have a new court reporter. This is my normal court reporter that's been here for about 21 years with me, but she's back with us today. Her name's Mary also. Please raise your right hand. If you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. I do. I don't know, is anyone going to need the screen?
No. Mr. Barber, I'm sorry, Jen.
No, you're good.
You swore, okay. Mr. Barber, I thank you for your time today, this afternoon. I just have a few brief questions for you, okay? Yesterday, you testified to owning and working for a roofing company for decades, correct?
Correct.
Okay. And moreover, during your work in that role, you've never had the city of Willoughby cite you for some aspect of non-complying installation at any property that you had occasion to work at.
Correct.
Okay. Because, Mr. Barber, you knew what you could do and what you couldn't do with respect to installation of the roof, correct?
Correct.
Because you had that experience out in the field as opposed to in law books, you knew what you could and couldn't do, right?
Correct.
So the non-complying nature of the downspouts on your home could not have been accidental, correct?
What do you mean, by accident aiming them at? Are we talking about? No, I with the city, and I think it, since 1986, 2001, put on the same way. They were compliant with the city at the time. Nothing was ever said. In that area that I grew up in, it goes back to city recommended years in the 70s, 60s, 70s, because of the old sewer system in that ward. So the basements wouldn't flood out. They recommended pulling the gutters and letting them kick out onto your property, so your basements wouldn't flood out. So from 86, 2001, just did the exact same thing, and nothing was ever said.
Do you remember referring to that? Do you remember referring to that codified ordinance that we had looked at that regarded the discharge of water from downspouts on the side yards? Do you remember reviewing that with me on the screen?
Correct.
Okay. Based upon your review of that, right, based upon us looking at it together, do you disagree with the city's conclusion on how the downspouts were supposed to be oriented?
No, we never heard anything about the downspouts until we got the letter from you and the city. We talked to the city and then we complied.
Let's get in one order of what you just said. So you said that you received a letter from our office, is that right?
I think it was referring to the downspouts being pointed to the driveway.
Right.
Right.
And that was in 2022. Do I have that right?
Correct.
Because it would have preceded Mr. Keller coming out to the property in July of 2022, right?
Right.
Would have been most likely part of prompting that, right?
I think Mr. Keller came out after that.
Okay. And having received that letter from our office, but before Mr. Keller came out, is it your testimony today that you, after having decades of experience in roofing, having no violations historically that you can remember at all, that you had no concerns that when Mr. Keller was going to come out and look at it, that he would issue a violation for the way they were oriented?
Well, you had to meet with him, and I'm sure he got the complaint to come out. He wanted to come out and address the issue and look at what's going on, and came to the conclusion, let's just put a different downspout there and direct it away from her driveway.
So it was only when the city required it, though, that you actually took a hard look at it and considered what you should do about it, right? It was only when the city came out and told you.
Well, there's never any problem from 1986 to 2000 and what, 2022?
You knew what they were. You knew how they were oriented. You had decades in the roofing industry. You're telling everyone here today you had no idea there was any problem with how they were directed. Is that what you're telling everyone?
I'm telling you, I've done what I've done for years in that ward and that area, and never had any problems. There was never any complaints until your complaint came through, and when Daryl came out, we looked at it, we addressed it, we fixed it within a couple days, and we're done.
At any point before taking those corrective actions, did you consider my client's property, the effect of those downspouts on my client's property? Did you consider it?
Well, the downspouts weren't on your client's property. They were just kicked out onto our property and then went into the side yard.
Sure. Did you ever consider water reaching from those downspouts over to my client's property?
It would have had to travel 6 feet, and I've never seen any water coming out to that extent that would travel all the way across to her driveway.
Did you ever, at any point before the city made you correct it, consider the probability of harm being caused because of the direction of the downspouts and the proximity to my client's property?
No, because there was never any issue. Nobody ever said anything.
Weren't you in fact placed on notice by us before the city came out? But despite being placed on notice by us, took no action until the city made you?
Well, we wanted to see if we were in compliance, if the city who's permitted the whole project, what their code was or rule was. And once he came out, told us what to do, we remedied it right away.
Why did you do it? Why did you make the correction?
Being a good neighbor, that's what the city wanted us to do. Good resident wanted to do. He said, let's just change this a little bit, and everything will be fine. The water will now go away from her, parallel with her driveway, and go into the flower beds. So
it wasn't to save yourself from the consequence of a violation. It was to be neighborly?
Well, for 1986 through we got the letter, there wasn't any issue about a downspout pointed towards the driveway.
Didn't you also knowingly disregard Kathleen Crozier's request for a swale, which would capture the water from your rear yard, and instead reject it?
In my mind, with the city, we had a swale there, but the swale that your engineer drew up, I just quite frankly, from our engineer that testified, it would be a liability hazard. And with the property being R60, there's not much room between her driveway and our property line. Matter of fact, her edge of her driveway is pretty much on the property line. So it would be a liability issue if you were to, go ahead with what we saw from your proposal.
I believe you said yesterday, you didn't have, first of all, you said everything you just said yesterday, right? That's consistent. But I believe you also added, because you didn't have to. Am I right?
Because it was already approved in 1990. It was all closed in 1990.
Isn't that the exact situation with the downspouts, that you didn't do anything until you had to? Right after the city told you had to?
Never any issue.
I have no further questions.
Thank you. You may return your seat, sir. Rob, please call your next witness.
Sure. Plaintiff calls Ms. Susan Barber.
Swear or affirm that testimony about to give will be the truth, the whole truth, and nothing but the truth. Whenever you're ready, Mr. Brown.
Thank you. Ms. Barber, I thank you for your time this afternoon. Ms. Barber, let me start by establishing a bit of a chronology. So, before the city ever came out to inspect the downspouts or do whatever inspection they did, you had received a letter from our office, correct?
Correct.
Do you remember reviewing it?
Yes.
Okay. Do you remember it including a demand for reimbursement of estimates and a demand for implementation of a swale per the old as-built we've all looked at in this case?
Yes.
Okay. And attached to that was also the survey from Polaris and the estimates themselves, right?
Right.
Okay. Now, yesterday, you testified that the manner in which the water drains off of your patio is not what you'd prefer today. Do you remember saying that?
I said that.
Okay.
Oops, I'm sorry.
Oh, I'm sorry. Do you remember also testifying that you may consider the installation of some type of swale, just not the one Ms. Crozier's expert had designed, rather a reasonable one? Do you remember saying that?
Okay.
Do I have that right? I just want to establish that.
Yeah. Repeat that again.
Sure. Do you remember yesterday testifying that you may consider the installation of a swale, just not the one Ms. Crozier's expert designed, rather a reasonable one? Do I have that right?
Reasonable. Maybe safe. Fine.
Sure, sure.
If that's what I said, that's what I said.
I don't want to put any words
Okay.
in your mouth. I just want to make sure we're on the same page, right? Mm-hmm. So a swale is a possibility, just not that one, right? You would consider it, right?
I would consider it if it's deemed necessary.
Is that what you said yesterday, deemed necessary? Or is that something you're adding today for the first time?
I'm going to add that today after hearing our expert speak.
Having established this chronology of you coming to these, we'll call it, new ideas, right? A preference in terms of how the water drains off the patio, the possibility a swale could be installed. That all happened at least 2 years, right, after receiving that letter from our office. Is that correct?
Yeah, could you repeat the last part again?
Sure. I'm trying to establish a chronology here. That's what I'm really getting at. So these new statements made yesterday for the first time that you would prefer the water drain in a different manner off of your patio, and you would prefer, or I'm sorry, and you would consider the installation of a safe swale, not the one Kathleen's expert recommended. These came 2 years at least after the letter that came from our office to you, correct?
So it wasn't thought about before the letter. Is that your question?
No, I'm just trying to establish I'm trying to establish that there is a difference of about 2 years between you saying what you said yesterday for the very first time and the letter that we sent to you making requests.
So there wasn't much said in between that time because we turned it to our insurance company.
Do you recall having a deposition with me where I asked you questions?
Yes.
Do you remember at any point voicing those ideas, the ones we just identified, you'd prefer the water to drain differently off the patio, or that you may consider a swale? Do you remember voicing those at all?
I answered the questions you asked, so if you asked me that, I wasn't adding any other things I wanted to do because I was just answering your deposition questions.
So, given everything we've just talked about, you had the opportunity to take action between the date of receiving the letter and today along the lines of those new preferences you expressed, correct?
Along the lines of the new preferences I just expressed, once we turned it over to the insurance,
Objection.
Overruled.
Go ahead.
and I'm sorry, ask it again?
Sure. Honestly, I lost that question. Let me try again. I'm doing my best. So, after receiving the letter from us in 2022 that gave you notice that Ms. Crozier wanted these things done,
Correct.
it wasn't until yesterday that you voiced those preferences. I believe we've established that.
Correct.
What kept you from voicing those preferences if they pre-existed yesterday between then and now?
All right, I'm going to approach for a second.
Sure.
Trevor, please move on or ask your next question.
Sure. So, rather than undertaking the actions that were requested by my client, you instead videotaped my client's property continuously for 4 years and did not take the corrective action, correct?
We took no corrective action. Yes.
But now in open court, with the jury watching, with the courtroom as it is, you're expressing these preferences about the patio and about a potential swale that's different than hers for the first time, correct?
Yes.
Okay. During this multi-year conflict, we'll call it, isn't it true you disregarded these requests of Ms. Crozier relative to what she was asking for?
And what particular requests?
So remember we covered the letter? So
Yeah.
there is
If you could go, there's a couple letters. There's.
So in 2022, there was a letter that made request for a swale. Do you remember that one?
Yes.
Okay. So isn't it true that you disregarded that particular
I'm
request?
not gonna allow this question.
Okay. Okay. Let's go a different direction. In watching what was occurring between the point in time you received that letter, right, that we established around, we'll call it summer of 2022, and the beginning of this trial, did you at any point consider my client's or her property's safety in relation to the water coming across the property line?
I never knew there was an issue. I got a letter. I never knew there was a safety issue.
Didn't you videotape the backyard for
Correct.
4 years?
Correct.
Okay. Despite that, no knowledge of an issue.
Correct. A safety issue. Correct.
At any point during that same period, did you consider the probability that harm was being caused to her garage and driveway?
I did not think that even if there was water, that it was causing harm to the driveway or the property.
So, even if, I want to break this down, even if there was water, your testimony today is you didn't have an understanding of it creating harm?
Correct. I did not think it would cause a physical harm.
Why did you videotape it for 4 years?
Not because I was looking to see if there was harm, because I wasn't seeing what, I had not seen anything that she had seen.
Why then did you make alterations to the backyard area around the flower bed area? Why then did you make alterations if you weren't?
And what alterations were those?
Well, you had mentioned to me yesterday that you stopped piling up the mulch on the flower beds.
Correct.
Right?
Correct.
Didn't you also allow that area that was the edging between the grass and the flower beds to be filled in?
Naturally filled in, yes.
So did you actually fill it in?
I don't recall if I moved, the only way it would have been filled in is to move some of the mulch forward. I honestly don't remember. But
So if you did not believe there was a probability of harm being caused, why would you do those things?
because there was a complaint.
Can you
Do I-
expound upon that? What do you mean by that?
So I didn't think I was allowed near that property, wasn't supposed to be touching it. So, but I mulched just very lightly because I'm like, that should be okay. I kept it away from her property. It was not an admission of guilt, if that's what you're looking for. It was just, I'm not really allowed to touch this. I haven't been able to mulch. I haven't been able to do much in that area at all for over many years, 2 years.
Was it for the purpose of making a change that would help? the situation, or was it for an appearance?
Was what?
What you're talking about that you did, right? What's the purpose behind it?
But
Was it
again,
to actually help Ms. Crozier, or was it for the appearance of having less of what she complained about present?
I don't really think it was either. It was more my plant. I did lose a plant. It was more just to keep things alive. It's bare dirt right now, which is actually not good for back there. So for a couple years, I haven't done anything other than just very slight mulch, and also I think to preserve the appearance. I think I had to ask permission if I could mulch. So I just tried to stay away.
So your testimony today is that it wasn't for the purpose of alleviating concerns of Ms. Crozier, and it was not for the purpose of appearances alone. It's neither?
Objection. It's been asked and answered multiple times.
Sustained.
Okay. If you really wanted to resolve the problems Ms. Crozier was complaining of, wouldn't you have gone farther than those actions that you took relative to the flower beds and the edging and the gap between them?
We hired an expert to review the swale and all of that. We are not experts in swales. We hired an expert for the patio to put it in. And we're relying, I mean, he's licensed, it got approved, everything was approved. Had no idea ever that we would be sitting here today by putting a patio in our backyard.
So, nothing about that letter you received in 2022, but did not perform what was requested in it, would have alerted you to that.
Objection.
Sustained.
I have no further questions. Thank you.
Thank you, ma'am. You may return. Plaintiff may call its next witness.
Your Honor, plaintiff rest.
All right. Mr. Doucette.
Your Honor, the defendants will not present additional testimony from anybody at this point.
And ladies and gentlemen, I'm going to ask that you take a 5-minute break. I'm going to address some quick legal matters with the jurors. We'll bring you right back out here for closing arguments. Thank you.
The last time I'll get to say thank you for your indulgence, thank you for your time, sincerely appreciate it. I'm just going to repeat the request of my client. She is requesting $1 for punitive damages and entitlement to attorney fees. To suggest that this is some trick is ridiculous. Literally, we are asking for entitlement to attorney fees. Literally, this is a case where we took the time and effort to go through all of this to get it. That is why we're asking for entitlement to that. As for all of the law and the instruction, that's going to come from the judge. All I want to emphasize is there was notice of the issues. There was an opportunity to correct the issues. The only ones that got corrected, the city made them do it. It's not until today, or not until yesterday, that apparently big new ideas about how things could have, should have, would have happened. We're here today because that never happened. Because we had to go through this, put it before you, and get the result that we hope you believe we're entitled to, and we believe we're entitled to. Thank you for your time.
Mr. Doucette.
Thank you. Big new ideas coming out today from who? From Sue Barber? Engineering ideas from Sue Barber, dragged out of her by this lawyer. Wouldn't you prefer your patio to drain some other way? Wouldn't that be nice? I guess so. You prefer that. Now it's dropped back out. And just like I said, it's twisted up. You just told us, Drew, you prefer to drain some other way. She doesn't know anything about that. She hired somebody to put a patio. She didn't even know how they drain until she got sued. She takes a hose out and pours it, so I guess it does drain over there. But then the engineers are telling her it goes in a gravel pit, disperses evenly. So whether she prefers her patio drains one way or another way isn't a reason to punish somebody. Would accept a reasonable swale that's not going to hurt somebody when they step out like that thing Gail designed from above, not realizing it until it was pointed out that that drain goes into something that goes in the basement and she can't do it by the ordinance. A civil engineer who didn't look at the ordinance that says what she can do with that drain. So then she comes up with an underground burrow pit or dry pit or whatever they called it to put the water in some other way, but still leaves these slopes for people to step out of a car and fall in. And they hesitate to install something like that before they talk to an engineer and they should be punished for it? That doesn't make sense to me. So when I say it's a trick, as a lawyer, it's a trick. Because it says right here, the purpose, if you were in a case that really needs punitive damages, and we can imagine cases that you really need to punish someone, okay? And the purpose of it is to send a message, okay? And is the message that's to be sent here, don't work with your city and do what they tell you to do? Which is exactly what these people did at every step of the way. The judge's instructions will tell you, punitive damages may be awarded against the defendants as a punishment and to discourage others from committing similar wrongful acts. And yet, we're going to discourage others from doing wrongful acts by awarding $1? See, that's the trick. The trick is to forget what punitive damages are for and jump over it to get to attorney's fees. You don't award attorney's fees to punish people. They're just a component in a case where you have this outrageous behavior that warrants punishment. And then you can get there. But to skip that part, to make it seem benign, to make it seem acceptable, to ignore that part of the instruction. You stand up here and say, just $1 will do it. To get to the fees. We get the chance first to decide whether or not this is a case where punitive damages at all are warranted. Yes or no? If the answer is no, we don't need more. If the answer is yes, this is the kind of thing society should be outraged at. These two neighbors are in a disagreement where the engineers themselves are presenting information that's complicated and different, and we're going to punish these people for not figuring it out fast enough before the lawyers file a lawsuit. If that's really what this case is, or not. It's only then, if you decide to award punitive damages, that you figure out what the amount would be, and then if you decide to award punitive damages, then whether or not attorneys fees be paid. Whether they should also pay this lawyer to go through this process. After talking to the city and finding an engineer, you guys
Mr. Grauer, any response?
I have nothing further. Thank you.
All right, ladies and gentlemen, at this time, I'm going to provide you with instructions regarding punitive damages. I will put them up there on the screen. I'm going to read them to you. You're going to get copies of them again in the back. And I'll review with you the verdict form as well to make this decision. So let me put this up on the screen for you. Having found that the plaintiff is entitled to compensatory damages against the defendants, you may also consider whether you will separately award punitive damages. Punitive damages may be awarded against the defendants as a punishment and to discourage others from committing similar wrongful acts. You are not required to award punitive damages to the plaintiff, and you may not do so unless you find that the plaintiff has met her burden to prove by clear and convincing evidence that the defendant's actions demonstrated actual malice. Actual malice necessary for an award of punitive damages is defined as a conscious disregard for the rights and safety of another person that has a great probability of causing substantial harm. Substantial means major or significant and not trifling or small. Clear and convincing means that the evidence must produce in your minds a firm belief or conviction about the facts to be proved. It must be more evidence than that simply outweighs or overbalances the evidence opposed to it. Punitive damages are not automatically awarded in cases where a defendant is found liable. If you award punitive damages, the amount should be fair and reasonable under all the facts and circumstances. It should not be excessive nor influenced by passion, sympathy, or prejudice. If you award punitive damages, it should be presumed that the plaintiff has been made whole for her injuries by the award of compensatory damages. In determining the amount of punitive damages, you may consider all the following. The harm caused was physical as opposed to economic. The tortious conduct evinced an indifference or a reckless disregard of the health or safety of others. The target of the conduct had financial vulnerability. The conduct involved repeated actions or was an isolated incident. And the harm was the result of intentional malice, trickery, or deceit, or was mere accident. If you decide that defendants are liable for punitive damages, you must also decide whether defendants are liable for the reasonable attorney fees of counsel employed by the plaintiff in the prosecution of this action. If you decide that the defendants are liable for attorney fees, the court will determine that amount. In deciding punitive damages, you must not consider whether either party had insurance. Any assumption that either party had or did not have insurance is not relevant and may be wrong. You must not add to or subtract from any award based on any assumption regarding insurance. You must resolve all issues presented to you only on the evidence admitted and the law in these instructions. To conclude this case, it is necessary that at least 6 members of the jury agree upon this verdict. The members of the jury agree upon the verdict must sign their names in ink to the form of verdict to which they have agreed. The foreperson need not be among the 6 jurors who have agreed in order to reach a verdict. If 6 jurors cannot agree, you are instructed to report this to the court. Now, in regards to that form, there's two parts to this. Verdict as to the punitive damages claim. The first is that you make a finding whether the plaintiff is or is not entitled to award of punitive damages based on the instructions I gave you. So it reads, we, the jury, being duly impaneled and sworn, find the plaintiff. You see an asterisk symbol followed by a blank line with the directions for the asterisk where you insert the word is or is not in accordance with the finding of at least 6 of you, is or is not entitled to award of punitive damages. Those agreeing to that will sign their name on the appropriate line. You then have some directions. If your answer is that the plaintiff is entitled to award of punitive damages, then proceed to the next question. If your answer is that the plaintiff is not entitled to award of punitive damages, then you shall not proceed to the next question and your deliberations are complete. Next question reads, we, the jury, make an additional award to the plaintiff in the amount of, and you see a dollar sign with a blank line, you'll put the dollar amount, whatever it is. If you do award punitive damages that it is you're awarding, you put in that blank line. You're awarding that amount as punitive damages against the defendants Eugene and Sue Barber, and we decide the attorney fees, and you see an asterisk symbol with a blank line where you're directed to insert the word should or the 2 words should not be awarded against defendants Eugene and Sue Barber. Again, you only make this finding in the second question if you've answered that the plaintiff is entitled to punitive damages. You will then sign your name on the appropriate line. Now, ladies and gentlemen, I'm going to send you back to the jury room at this time. In addition to these instructions, you can rely on previous instructions that were given to you in regards to deliberations, how to conduct your deliberations. So I ask that you those be incorporated the verdict, you would say if we needed to